Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I want to do a shorter form recap of Justin Baldoni's filing from last night where he's opposing Blake Lively's motion for fees and sanctions under Section 47.1. But first, I got some interesting comments related to the Taylor Swift story from last night as well. A process server who was allegedly going to serve Taylor Swift with papers from Justin Baldoni's legal team was arrested at Travis Kelce's property. He reportedly broke onto the property at 2 a.m. We don't know that they were actually even there. He could have just been picked up by security cameras, but I'm not sure they were even actually at that property. Anyways, a woman found me on TikTok and said that the man that they arrested is her uncle. His name is Justin Lee Fisher. He was arrested on the 15th. According to his niece, that side of the family has gone defensive, then silent. She's hearing different stories from family members right now. She says he hasn't been a private investigator for very long, maybe a few years. He had left the police force, became a truck driver, then did insurance, all in the last 10 years. And I guess somebody had pulled his records and found out that he was possibly let go from his last law enforcement job due to domestic violence charges. Now, this woman said that she's been in no contact with her uncle for many years for various other reasons that she didn't specify, and I wouldn't ask her to, that's personal. But she's not surprised by his behavior. Okay, let's go over some of this response. And I'm going to be going over this again with Omar, I think, later tonight, probably late tonight, so he can explain some of the legal stuff. For the second time, plaintiff Blake Lively seeks draconian relief under a new California statute, California Civil Code Section 47.1, which creates a qualified privilege for any person claiming sexual harassment under defined California statutes. Section 47.1 authorizes an award of reasonable attorney's fees, treble damages, and punitive damages for a failed defamation claim against a party asserting sexual harassment claims without malice and with a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. So 2 points here. The without malice thing is pretty important, and she hasn't actually proven any of her claims. In fact, her only backup when she filed this motion, her 47.1 motion, was a declaration from someone who worked with Wayfair on a different project and said that they had a negative experience with Justin Baldoni. We've all had negative experiences with people that can mean fucking anything. In fact, I've had a personal negative experience with Blake Lively in this case, and that certainly doesn't support claims of sexual harassment. It also says, with a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. I don't know if she really had a reasonable basis. Remember, her claims changed quite a lot, especially related to the dance scene from her first complaint to her first amended complaint. There is video evidence that she was not truthful in her account of what happened. So even if you give her the large benefit of the doubt, she is at the very least not 100% honest about what happened. And that, when you're trying to make yourself a crusader for women and girls' safety, is kind of unforgivable, if you ask me. Thus, whether the privilege and remedies afforded by Section 47.1 apply turn not on the Wayfair party's underlying conduct, but on Lively's motive and intent, i.e., whether Lively asserted the claims without malice and with a reasonable basis, factual issues that remain to be tried in the main case. So trying to get treble damages, punitive damages, and all that before the trial even happens is fucking wild to me. Section 47.1's express language raises multiple constitutional concerns which have not been addressed by any California court, including its curtailment of free speech and a litigant's right to petition guaranteed by the First Amendment, as well as potential violations of the Fourth Amendment's prohibition against excessive penalties, treble and punitive. So when they're talking about the factual issues here, there's a footnote that says Baldoni's WME agent Danny Greenberg testified, and then of course it's redacted so we can't see what he said there, but I believe that is the agent that Ryan Reynolds had called and said that Justin was some kind of deranged predator. But correct me if I'm wrong about that. Further, Lively does not explain why California's presumption against extraterritorial jurisdiction does not apply to Section 47.1 when Lively is not a California resident and the alleged harassment, which is the basis for her claims, occurred in New York and on the New Jersey set where It Ends With Us was filmed. Lively, the statute, and its legislative history are also silent on whether these remedies are available for dismissal of a consolidated complaint where the issues of liability and punitive damages have not yet been determined by the trier of fact. The extreme remedies created by Section 47.1 require factual findings that Lively asserted her claims without malice and with a reasonable basis. This inquiry turns on Lively's motives, to wit, whether her complaints of sexual harassment were made with malice and with a reasonable basis, factual determinations within the province of a jury or the court on summary adjudication based on admissible evidence. No trier of fact has made these factual determinations, which are central to the Wayfair party's defense, and will be ultimately determined in the still pending main action. Lively nevertheless contends that Section 47.1's remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. And in my opinion, she's an asshole and a nuclear moron for abusing that. Here, however, neither the dismissal of the Wayfarer party's defamation claim nor an award of penalties under Section 47.1 would achieve this statutory goal of preventing ongoing, protracted litigation over the same factual issues which determine the applicability of Section 47.1, to wit, whether Lively's claims are valid. No California court has provided guidance on this issue, including whether a court's determination before trial, in the context of Section 47.1, of the complainant's motive and intent would divest a defendant of his right to a defense at trial, or by summary adjudication, based on admissible evidence. Here they're talking about inconsistent outcomes. For instance, if this court applies Section 47.1's privilege and remedies at this early juncture, what happens if a jury later finds her claims lack merit? Nor has any California court explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the trier of fact. Lively, in fact, does not directly address the key issues of her motive and intent, but deflects by recycling the full breadth of her allegations of the Wayfarer party's reported misconduct, which are the basis for pending Rule 11 and New York Rule of Professional Conduct 3.6 sanctions motions. The bulk of these allegations have no bearing on the discrete factual issues relevant to Section 47.1 analysis, specifically whether Lively had a reasonable basis for her sexual harassment claim and acted without malice in asserting it. For instance, Lively argues that the court dismissed the Wayfarer party's defamation claim against Ryan Reynolds and Leslie Sloan for failure to plead malice, sufficient evidence of a smear campaign, and strong evidence, please. Lady, please. And strong evidence that the Wayfarer parties spread negative stories about Lively. Sufficient evidence of a smear campaign. You don't have sufficient evidence of smearing shit. Whether the court found that the complaint failed to plead malice sufficient to state a defamation claim against Reynolds, Sloan, or New York Times, or spread negative stories about Lively is irrelevant to Lively's motive and intent in asserting her sexual harassment claims. And here they're pointing out the court did not dismiss the Wayfarer party's defamation claim for failure to plead malice. Rather, the court found that Lively's complaint, the only basis for the defamation claim asserted in the cross-complaint, was privileged under California's litigation and fair report privileges, and thus it was unnecessary to reach the issue of malice. So she's been very disingenuous with that. Shortly before the dismissal, she had all those organizations writing their stupid amicus briefs. And then right after the dismissal, she made an Instagram post suggesting that the court had dismissed Justin's lawsuit because it didn't have any merit. And that wasn't true. And she cited all those organizations that came out with their amicus briefs. But Ezra Hudson, one of her attorneys, is on the board of at least one of those organizations, as far as I remember. Again, correct me if I'm wrong, but it wouldn't be the first time Ezra Hudson has done some stupid shit. Okay, yeah, so she's a board member at California Women's Law Center. The motion before the court remains short on the relevant factual issues and devoid of legal authority that might allow the court to award the punitive remedies provided in Section 47.1 at this stage of the litigation. Lively's motion should be denied because, among other things, Lively fails to show that Section 47.1 or California Civil Code 3294 have extraterritorial application. Lively fails to present new facts or law that might warrant reconsideration of the court's previous denial of relief under Section 47.1. No trier of fact has found, based on admissible evidence, that Lively's sexual harassment claims were asserted without malice and with reasonable basis. Lively fails to show, and no trier of fact has found, clear and convincing evidence, the malice required for punitive damages as required by Section 3294. Plaintiff has not proven, and no trier of fact has found, the actual compensatory damages required as a basis to calculate treble or punitive damages. Like I said, I'll have Omar to go through all that a little bit more thoroughly later on. There's also this declaration by Ellen Garofalo, one of the attorneys for Justin and Wayfarer. She says that she deposed Vivian Baker, Blake Lively's makeup artist, Warren Zavala, Miss Lively's talent agent at WME, and Danny Greenberg, who was Justin Baldoni's former talent agent at WME. All right, guys, that's all I got for now. Blake will probably respond to this. I don't know if it has to be within a week or 2 weeks. I can't remember. But like I said, I'll be back later on to talk a little bit more about that. So thanks for watching, and I'll see you all soon.